This would be a good time to switch off mobile phones, please, or to put them on silence. And if you do have to take a call, please leave the room to do so. Can everybody at the back hear what I'm saying? Thank you. There's two appeals before me. Appeal A is in respect of an enforcement notice dated 13th of September 2024 concerning... Great. Appeal A is in respect of an enforcement notice dated the 13th of September 2024 concerning land known as Old Tiger Stables House, 22A Northfield Road, Soham, Ely, Cambridgeshire, CB7 5UF, issued by East Cambridgeshire District Council. The breach of planning control stated in the notice is the failure to comply with condition 10 of application E/91/0367/O, which approved proposed 1.5-storey dwelling and garage for stable owner. Condition 10 of that outline planning permission, which was granted on the 4th of November 1992, reads as follows. The proposed dwelling shall be first occupied by Miss L. Webster and any dependents residing with her, and thereafter by persons involved in the management of the adjacent livery business currently known as Old Tiger Stables. The stated reason for the condition is the dwelling hereby permitted is sited in a rural area outside any established settlements where the local planning authority would not normally grant consent for such a development except to fulfil an essential rural need. The appeal in Appeal A is under Ground A only, which is where the condition 10 of the outline planning permission ought to be discharged. Appeal B is in respect of an application to remove condition 10 of the outline planning permission under section 73 of the Town and Country Planning Act, which was refused by the council on the 10th of July 2024. Could the council please outline the fire alarm procedure if the alarm goes off again, please?
Yeah, we're not expecting any further tests, so if the fire alarm does go off again, people can leave by the stairs down through the back exit. Please don't use the lift, or there is a fire exit here with an external fire escape, which people can use, and will direct you in the event of another fire alarm. And the meeting point is the car park at the front of the building.
Great, thank you. The hearing today will be a structured discussion, which I shall lead based on the agenda. Has everybody got a copy and can see a copy of the agenda? Great. The purpose is to enable everyone who wants to put forward their points of view and to help me get the information I need to reach my decision. But before we start the discussion, there's a few formalities I need to complete. Firstly, could I start by taking the names of everyone who wishes to speak and their interest in the case, starting with the appellant, please? Oh, would you mind switching your microphone on, please?
So yes, good morning. My name is Rowan Clapp. I'm a barrister at Cornerstone Barristers, appearing on behalf of Miss Webster. To my left sits Mr. Keith Hutchinson, who's a partner at Hutchinson's. To his left is the appellant, Miss Webster, who's the appellant for planning permission, or the appellant, or the applicant for planning permission, the appellant in respect to the enforcement notice. And further down the line is Miss Amy Richardson of Ashton's Legal, where she's a partner. And I think it's fair to say you don't want to hear very much from me today, sir. You'll be hearing mostly from Mr. Hutchinson and from Miss Webster.
Rachel Forbes, Planning Officer for the Council.
Dan Smith, Planning Team Leader for East Cambridgeshire District Council.
David Moran, Strategic Planning and Development Management Manager. Yes, sorry, it's Moran, M-O-R-R-E-N.
Rachel Mackenzie, Planning Enforcement Officer.
Jeline Roman, Planning Enforcement Team Leader. Sorry, Julene Roman. Yeah, I'll spell it. It's Julleen. Roman. Yeah.
Angela Tyrrell, TYRRELL, Senior Legal Assistant for the Council.
Number of times, unfortunately. I don't think it really falls into the category of people who want to speak, but I do have two letters from local members of the public that I'd like to pass up to you, if I may.
Okay, I'll deal with that as late evidence when we get to it.
Say yes. Yeah. No, I may be prefacing something that doesn't arise, but so far as I've read Mr. Young's submissions in respect of the issue that he's concerned about in this appeal, then it's not relevant for the purposes of this appeal. So I'm slightly surprised that he wants to attend. And then the second point is that it's not clear to, well, it should at least be made very clear to Mr. Young that if he does come on a site visit, it's not a case where further submissions can be made or questions can be asked or representations can be made to you. So,
Well, yes, I need to be clear that when I carry out the site visits, it will be after discussions. I'm there to see the site in its context. If there's anything that anybody thinks I haven't seen, then by all means they can point it out to me, but it's not a place for discussions. And as I said, it's privately owned land. It's a matter for the appellants to consider whether they permit anyone else to enter the land.
No.
Okay, that's fine. Okay, so I will carry out the site visit with someone from the appellant and someone from the council, and no discussions will take place concerning the merits of the appeal as well. I'll need to carry out the site visit while it's reasonably late, so it would be good to start by 3:30 this afternoon. Having read everything that's been submitted so far, I anticipate concluding today by 3 o'clock. We'll have to see where we are at lunchtime. Otherwise, I'm happy to sit until 5 o'clock. But if we are going to be here that way, I think we're going to carry out the site visit immediately after lunch, but we'll see where we are on break for lunch. We'll need to have a discussion about what conditions might be appropriate were I to allow the appeal in appeal B, and whether any conditions should be substituted for condition 10 of the outline condition in appeal A. This is standard procedure and it does not indicate that I've made up my mind with the appeals, nor was the discussion affecting the party's position. Is there a list of other agreed conditions should appeal B succeed?
I don't think we have one. So no, we haven't got one.
That should be a fairly brief discussion. I'll put it on the agenda and but maybe in advance over lunchtime, if we haven't got there by lunchtime, if everybody can look at the original permission, the conditions which are attached on there, and then
So, yes.
have a discussion about which ones might be relevant to create I'm not inviting any applications for costs. If any are to be made, it seems to be before.
Additional land. One of the things that the council have raised in their combined statement of case was that it wasn't clear to them that Miss Webster had actually approached anyone at the relevant time.
So these people had been approached.
They had been approached.
And has the council seen these letters or?
No, they haven't. I haven't.
No,
subjected
we
them to
haven't.
I can say yes, of course, yes. Yes. I've got loads, I think so.
Well, I don't want to just give them to the council first. I'll give the council a moment to read them and I'll ask your comments as to whether I want to accept things later.
Of course, so just one more short point. If Mr. Crisp and Mr. Murfitt wished to, they could have attended the inquiry this morning and made these representations. That would have been completely lawful and appropriate in the circumstances. This effectively just saves them the hassle of doing that. So yes, of course.
I think they raised sorry, sir, I think they raised points that they could have made today. They also could have been provided presumably much sooner in the process. The lack of evidence of sort of seeking out or having the opportunity to use other land is something that we did raise quite early on in the planning process. And I note that one of the letters is dated Friday, just gone, and the other is undated. I think they're fairly unspecific, and I don't think it goes to a major part of our case. So I think we're happy for them to be introduced, but obviously we're disappointed they weren't provided sooner.
Mr. Douglas, it's a letter from my solicitor at Keystone Law. The reason it's a late submission is because the appellant's solicitor contacted me on the 18th of December and asked me to sign a deed of variation over the Section 106 agreement, which we obviously explained the reasons we would sign it and the reasons we wouldn't sign it to try and come to an agreement to get an agreement in place. We received no response from the appellant or her legal team. And on the 20th of December, only 2 days later, a submission was made onto the East Cambridgeshire District Council portal of a 106 deed of variation, excluding both myself, my wife, and Mr. Slater. So my solicitor has basically outlined that, you know, we would legally challenge any 106 that was discharged without the involvement of all the landowners.
Okay, so this is a letter from your legal representative concerning a deed of variation. Is there any deed of variation for me to consider as part of this appeal at all?
Perhaps just address you on the issue that relates to this submission.
Just one moment. So it doesn't consider it doesn't deal with any issues in the appeal. It's purely a deed of variation which you've been contacted about.
Well, what was confusing me is on the appellant's application form, there was a request to discharge 2 points. It was point 10 of the restrictions which you've raised, but also to remove clause 2B, which was the occupancy clause of the Section 106 agreement. Nevertheless, despite that being the restricted request of the appellant's application, her legal team have written to me to try and discharge the whole Section 106. Part of the reason I'm speaking is to explain why that won't be possible unless certain conditions are met.
Right. Well, I think I understand. I think to be clear to everyone, because I saw on the application form that there's mention of a variation to a legal agreement. So I'm not here to vary any legal agreement. There's no legal agreement before me which is varied. I'm bound to consider any legal agreement that gets submitted before I issue my decision. But my understanding is that the legal agreement which is in place merely reiterates the condition. Is that correct?
That's right, sir. And what you can do insofar as you deal with that original section 106 agreement is you can either disagree with us and say that it remains in place, or you can remove clause 2B.
Well, I can't vary it, can I?
No, you can't. Well, insofar as removal of clause 2B is a variation, you can do that.
But if I receive it, that's something that the main parties are discussing between themselves separately.
Yes, the main parties have attempted to agree a section 106 variation. That's something that's been going on in the background. Those that instruct me, Ms. Richardson's been attempting to agree that with Mr. Slater and Mr. Young, who are landowners who originally formed part of the total section 106 area. The issue that arises in this case is not one in which you need Mr. Young's approval. He doesn't have to sign up to it or not.
Well, I don't need the deed of variation either, do I?
No.
My understanding at the
No.
moment. So regardless of whether the deed of variation is agreed by any parties, it's my understanding, without seeing it, is that it isn't going to affect my decision. Is that right?
Insofar as it relates to whether you do or don't remove clause 2B, which is what
I'm
you're
not.
doing.
I'm not removing anything from a legal agreement anyway. It's
You
the
can
conditions that I'm dealing with.
discharge, yeah.
The
yes.
condition.
Yes.
Yes, that's right. So
There is also the application under section 106A to amend the section 106 agreement.
which is a matter between the main parties. That's right,
Yes,
isn't
yes,
it?
yes.
Yeah, and nothing, and not for me to determine.
Oh, so
I'm
sorry,
not
sir.
dealing with the appeal there. There's no appeal with regards to variation of the legal agreement.
I understand that is part of the appeal, sir.
The appeal is the variation of condition under section 73. Is that correct?
I had understood things differently, sir. I understood that we were dealing with an appeal under section 73 and an appeal under section 106. I think probably it's B, isn't it?
Mr. Douglas, even if the restriction 10 is lifted with section 2B in place in the section 106 agreement, it's meaningless because they both mean the same thing. So the section 2B, which is the occupancy clause of section 106, is the same text where it says that the occupancy of the house must have the land and run the stable yard. Section 2C means that the land can't be subdivided.
I understand. I think where I am at the moment is I am thinking that I don't need to. There's no appeal before me to deal with the legal agreement. Is this? Should we return to? I'll complete my my opening statements. With regards to this late evidence, I think I'm going to need further discussions about whether we need to accept it. At the moment, I feel as though it's something which isn't relevant to my decisions. If it later becomes clear that it is, then I'll have to go back to the parties, I think, and discuss whether to accept it. Have either of the parties seen this late evidence?
I've seen it, sir. I have some submissions on it if you'd like to hear them.
No, not
I've
yet.
read it in
Thank you. Has
detail.
the council seen these late submissions?
Yeah, I believe we have seen this letter and we forwarded it on to the planning inspectorate.
Yes, no, it wouldn't have been accepted by my case officer,
the-
so I wouldn't
can I
have
see
seen
the
it. I think if you hold on to that for the moment, we'll return to this if relevant later. At the moment, I don't feel it is. Is there any other late evidence that anybody wants to submit, wants to put forward? Okay, thank you. As I said, I'll just complete my my opening comments before we move on to the agenda, before we return to this point on the legal agreement. I intend to take a break mid-morning and for lunch and mid-afternoon if still sitting, and I aim to finish no later than 5 o'clock. If anyone requires a break, please say. Please can we confirm the plans which were submitted with the application under section 73? My understanding is there's a single site plan dated the 23rd of August 2024. Is that right?
So no, a site plan wasn't submitted as part of the section 73 application because it didn't require it, because it was
Then-
referring to a condition.
Okay, why have I been provided with this plan as part of the application plans then?
It might be at the appeal stage. It asked for a location plan to be submitted. I don't
Okay,
know why.
so no plans were
because it linked-
submitted as
no,
part of the
because it linked
section
to-
73.
To an original permission, and it was varying or discharging a condition. I didn't need to submit a plan with it.
Okay, is that the council's understanding as well?
Yes, it is.
Okay, well, I've been, just to clarify, I've been provided with this site plan as part of the appeal documents, and it's labelled an application plan, but I won't consider it as part of the planning application documents. Aside from matters concerning the legal agreement, are there any questions at this stage about the procedural side of the hearing before we move on to item 2 on the agenda? Okay, so item 2 on the agenda is concerning preliminary matters. Before we go any further, regarding the legal agreement, is there anything you'd like to say on that, please?
So yes, but dig up the appeal.
It's just extreme.
I know, I'm so sorry. The proposal in the first instance was to remove condition 10 and clause 2B of the section 106 agreement. That was then refused. An appeal has been made against that, the refusal of that proposal. And if you look at the statement of case for the appellant, you see that what's proposed is to remove condition 10 and clause 2B of the section 106 agreement.
Yes, but which authority is allowing me to vary the legal agreements?
Section 106A of the 1990 Act. So if
Sorry, section 106, which subsection?
So I can take you through the subsection. So say that the application that was made in the first instance is section 106A3. That's the application by Miss Webster to the local planning authority.
Yes.
So that she was applying then to have the obligation discharged. And then if one goes to section 6, subsection 6, the determination by the local authority is whether the obligation serves a useful purpose. If not, section 106A 6B, then it should be discharged. Then one goes to section 106A 8, where a local authority determined under this section of the planning obligation shall have effect. The obligation as modified shall be enforceable as if it had been entered into in the date in which the notice of determination was given to the appellant. Effectively, where a local authority determined not to make the modification or discharge the relevant obligation, then a landowner has a right of appeal under section 106B1. And if so, applying section 106B4, subsections 6 to 9, section 106A apply. So you are in the position the local authority was in when the local authority was asked to discharge.
Yes, no, I see. But my understanding is that the legal agreement is a reiteration of the condition. Is that correct?
Yes.
And it is the same issues that we're dealing with.
So yes, although you would have to turn your mind to the
different
irritatingly
tests,
but
yeah.
slightly different test of useful purpose.
Yes, no, thank you. So with regards to, sorry, the neighbours' late submissions, you've read these.
I've read them, sir. I don't want to make too much of a big deal of this, but I read it with some surprise, noting that Mr. Young benefits from professional representation. Because what Mr. Young effectively says is that as part of a conveyance to him of some property which originally fell within the site, some drainage issues remain outstanding. And the way that he puts it in the letter is that he's unwilling to sign a section 106 agreement whilst those drainage issues are outstanding. And the way that he put it in the letter, or I should say his legal representative put it in the letter, was that he would sign a section 106 agreement if Miss Webster conveyed to him quite a substantial portion of land for free. I was surprised to see that put as an offer in open correspondence, but that's that's really a matter for his legal representative. But the short answer to this point, so far as the thing that he's concerned about is drainage, is if you turn up the officer's report in this case, you'll see if you'll note at paragraph 7.2.11, the officer says, the legal status of the land is a civil matter. That's the reference 7.2.11. It's Dr. Young, Mr. Young, raised this issue at the committee stage, or rather at the officer stage, I should say. It says the legal status of the land is a civil matter. The drainage issues at this property are separate to this application, cannot be addressed or resolved as part of this application. Now what I say is that's obviously right. You'll also see that the drainage authority have made no comment on the application. You've seen that. What we say about is that any dispute concerning drainage, alleged liability of Miss Webster in respect of any conveyance of property to Mr. Young. I don't know whether to call him Mr. Young or Dr. Young. I'm not sure what the convention is. I mean, no disrespect either way I put it. It's well outside the scope of what this appeal concerns. The property in any event that is owned by Mr. Young was conveyed to Mr. Young by a company called Milo Property Development Company Limited. And so any ventilation of that dispute, leaving entirely aside as to whether it's appropriate to deal with it in this forum, is between that party, Milo Property, and Mr. Young. And the issues effectively amount to either a neighbour dispute or a dispute concerning the conveyance of a property. So it's not for us or for you, sir, to put their case in correct legal terms, but you don't have the power to resolve any of those issues in any event. And in any event, you would be required, if you were going to try and take this issue on, to identify that there were drainage issues at the site in question, to apportion liability in respect of the same, and then conclude as to the appropriate remedy. You haven't had any evidence on any of the topics going to those matters. So what we say in short is that the thing that Mr. Young is concerned about is about a dispute that is basically wholly without your jurisdiction. Basically concerns a civil matter, not a planning local authority dispute, and is between him and a different party to the appellant in this case in any event.
Right, thank you. And the council's read this letter. Does the council have any comments on this letter? So yeah, please, I'll come back to you in a moment. I'll just ask the council if they've got any comments they'd like to make.
Thank you. I think the council's view is that the drainage matters are completely outside of this appeal. This appeal is purely relating to the occupation of that house. With regards to the section 106, the officer's report obviously covers the council's view with regards to how we consider it.
Okay, thank you. And I think, so Mr. Young, my understanding is that this late evidence concerns a potential deed of variation. Is that right?
So I'd like to respectfully correct some of the points that were put to you there. But
Unfortunately, I've got a lot to get through
I'm
today,
sure
so I want to keep it concise. I don't want to hear anything which isn't relevant. And as far as from what I've heard so far, it sounds as though this late evidence concerns a deed of variation between the council and the appellants, which you were contacted about. Is that's why it's late? That's why these representations are late. Is that right?
Yeah. So, you know, section 1 of the section 106A actually states that a planning obligation may not be modified, discharged, except when the local planning authority enter into it with the person or persons against whom the obligation is enforceable. Now, 4 out of the 5 landowners under the section 106 agreement do not wish to enter into that agreement. So I'm just questioning the legality of a unilateral agreement when on one document here we've got East Cambridgeshire Council, Lorraine Webster, Adam and Nina Young, Russell Slater, Louise Rebecca Scott Slater, Lloyds Bank, Santander, the UK mortgage lender, and the Homes Community Agency. And obviously when we weren't wishing to sign that because we do not believe it should be discharged, the legal team of Miss Slater have simply provided a second and reduced copy, which is East Cambridgeshire Council, Lorraine Webster and Lloyd's Bank. So I don't understand how on the 18th of December, a deed of variation can be allowed and asked for all of the landowners to sign, which would be the correct thing to do. And then simply when that's challenged on reasons which you'll hear from me later, a shorter unilateral agreement can be put in place. It just seems illogical to me.
I see. Is there any likelihood that I'm going to be receiving a unilateral agreement or a deed of variation at any point before I issue my decision?
The agreement is not, or the deed of variation is not a unilateral agreement.
But either, is there any likelihood that I'm going to receive either?
It was one way that was canvassed of solving the issue. The way that we're proposing you to deal with this is to simply delete clause 2B.
Yes, but is it likely that I'm going to receive a deed of variation before I issue my decision? Because if I do, I'm going to have to consider it. And if it is likely that I'm going to receive one, then I feel I need to accept these late representations.
Well, so that the deed of variation concerns a smaller parcel of land to which Mr. Young is not subject. So it's out with scope of his land, so it wouldn't be enforceable against him. It's a smaller parcel of land within the larger area originally governed by the Section 106 agreement.
Sorry, if I can get this straight in my head, if I am going to receive a deed of variation before I issue my decision, it's going to be concerning land which is only owned by the appellant, is that right? So it would be solely between the council and the appellant, is that right?
Yes, and I think Miss Webster's mother as well, maybe.
Mr. Douglas.
Just one moment, please, I'll just clarify.
Yes.
Right,
But
and is it likely that I'm going to receive any other deed of variation before I issue my decision? Yes.
No.
No. Okay, so what is this deed of variation that Mr. Young has been contacted about?
I think there was a desire to try and loop Mr. Young into the process. That was the deed of variation that was originally pursued, which was I think the original approach was to try and get all of the landowners that own land that was originally governed by the Section 106 area to agree to the variation of the Section 106 agreement. It's become very clear that Mr. Young and Mr. Slater will not sign any sort of agreed Section 106 agreement because they have this concern about drainage. You've heard by submissions about how relevant that issue is. We say it's wholly irrelevant. What was pursued in the alternative was a smaller area covered by a deed of variation. So the deed of variation that covers the whole site is not pursued anymore because it's obvious that it's not going to be agreed. We are pursuing potentially a deed of variation concerning a smaller site area to effectively remove clause 2B from the bit of the land with which Miss Webster is concerned.
Mr. Douglas.
Okay, yes, sorry, Mr. Young, to cut you off again, but if I can just understand, you have no intention of signing any deed of variation. Is that the upshot?
No. Well, if I could get respectfully just explain the matter to you, it would become quite clear because I think this is deliberately opaque. So even on that smaller deed of variation which is being requested, my property illegally resides on that land. And the reason being is that Miss Webster only applied for planning permission for half the property. She informed the council that my drainage system and of that of Mr. Slater's ran into a ditch, which would have been acceptable. Instead, there is a pond which my house drains into under the smaller parcel of land.
Sorry to cut you off.
Yep.
I'm going to accept these late representations just because this sounds like quite a complicated matter. I want to have all the information in front of me because I don't know what deed of variation I'm going to be receiving before I issue my decision. So if you could pass, you already have a copy, is that right? Does the council already have a copy of these late representations? If you could pass me a copy, please. We'll return to this later on today. I think I need all of the information before me because I don't understand what's being said here.
Yeah, I'm not sure it does make sense, but that's.
Thank you, sir. Thank you.
Can I?
Sorry, just one moment, just to confirm what I've been given a copy of here. I've got, if you could just stay up there, please. Sorry. So I've got a letter dated 9th of January 2025. Is this the letter that everybody's seen?
That the letter that refers to the amendment of the section 106 not being equitable?
Mr. Young,
Is that it?
is
That
this,
one.
this is what's been provided to both of the main parties already, is that right?
So you have the extended variation, which was given to me, was passed to me on the 18th of December. The letter from my solicitor, and then the variation on the 20th that was uploaded.
Okay, right. I think, could the council please take copies of this? Could you please make 2 copies? Keep one for yourself and pass one to the appellant. We'll return to this later on, and then I'll accept a copy myself. I haven't read that. I need both parties to have had a look at this first, before I can consider whether I'm going to accept it.
I
You said-
hadn't felt it necessary. I didn't think we would need to go down this road, but it is important just to put a marker down. I have spent time reading this correspondence in advance of this hearing. We have talked about it internally. It has been a distraction. You do have the scope, the power to award costs against a third party. That is something that applying for you to make costs in those circumstances is something we had hoped not to do. But if this does continue to become a distraction, and it does result in further work being produced outside the inquiry, I just put Mr. Young on notice that there's something that's an application that we'll have to consider making. And I say that just to be absolutely clear about what we're thinking, because in my respectful submission, the material that is included in that letter is wholly irrelevant. It shouldn't have been produced, and the third party's conduct is unreasonable. Whether or not that results in us making a cost application is another matter.
Yes, and sorry, Mr. Young, just to make clear, to explain what's being said here is when any parties are unreasonable in the appeal process, which results in any wasted or unnecessary expense in the appeal process for another party, they can submit for an application of costs against that party to cover their costs that are incurred in dealing with that. Now, what the appellant is saying, that that's something that they may consider if we get distracted here. From everything that I've heard, I still don't know whether this is relevant information. But I think you just need to be aware of that if there is unreasonable behaviour in submitting irrelevant information for me, then it may result in one of the parties incurring unnecessary or wasted expense, and I may have to make an award of costs, regardless of whether anyone makes that application. Okay, at this point, I think I'll wait until the council's got photocopies so that everyone can be clear that they've got copies of that.
So yes. And
I've said that I'll accept it as late evidence because I want to read it before I know whether it's relevant or not.
So yes, quite right. But the agreed position between the parties is that it is irrelevant.
Yes, and I think you need to be aware of that, Mr. Young, at this point, in case you want to continue referring to it. But I'll read it during an adjournment later on, and we can return to it.
Sorry, just for my own clarification, please. What is being agreed is irrelevant?
I think the appellant has said that it's irrelevant, and my understanding was that the council said that it didn't affect proceedings. Is that right?
This was a deed of variation they sent me.
Yes, sorry, one moment. Is that the council's position?
The council's position, I think, is that the drainage matters themselves are not relevant to this appeal. The council's position is also that it is unclear at this stage whether or not it is appropriate to enter into a varied legal agreement without all parties signing up to that. And on that basis and others, we have not yet entered into that agreement, which is why there isn't a varied agreement in front of you today. Just to be clear about what there is and isn't agreement.
Yes,
about.
I see. So you're not clear on whether the information in Mr. Young's letter regarding a varied legal agreement is relevant.
We're not clear on whether it's appropriate for us to enter into a varied agreement without the agreement of all parties who were in that original agreement.
And you see, the problem I have is
But
that,
the-
is that there is no varied legal agreement before me, but it's been indicated that one may be presented before I issue my decision.
This is the difficulty with Mr Young's letter, is that the letter doesn't raise some sort of issue of legal importance, where it says, well, I'm not sure whether you can proceed in this way, excluding me. The letter says, we'll sign your section 106 agreement if you provide to us a lot of land. That's what he says.
Mr Douglas, there's been a lot of representation made on my behalf, which has been unsolicited here. Actually, I mean, I'm not here to discuss drainage issues. I'm not here to get a resolution over a drainage system. I'm very clear on that. My main purpose of being here, sir, is to demonstrate to you, as the council have said, that I have a right not to be excluded from a unilateral agreement. That is my sole purpose.
And is that the summary of this later?
That's the summary of my presence here today, sir.
Well, so you'll have your own view about whether that's reflected in the letter.
Right, well, thank you, Mr. Young, thank you. And as I said, I'll accept a copy of this letter because I need to read it, I think, to understand what it's saying, and we'll see when we come, if it comes up again later. Moving on to the preliminary matters that I'd listed in the agenda, they should be fairly brief. One concerns a very minor point in a correction or variation in the notice. It refers to the planning permission as an application. Does anybody have any objection to that being corrected to the word planning permission in the description of the breach? No. An update to the National Planning Policy Framework was issued on the 12th of December 2024. Are any changes in the framework relevant to my decision?
Just that in paragraph 78, there's a revised method of calculating 5-year housing land supply. We've updated our housing supply report following that revision and revised method of calculation, and we can comfortably demonstrate in excess of 5 years worth of deliverable housing supply. Our latest report is published on the 23rd of December 2024, reflects that method and demonstrates we have 6.28 years worth of supply deliverable.
Is this disputed by the appellant at all?
No, sir.
No. So are there any other changes to the framework that the appellant thinks might be relevant?
We don't think so, no.
Thank you. And just to confirm the planning history, we have the outline planning permission and the reserved matters planning permission 920849, dated the 21st of December 1992. I've been provided a copy of that reserved matters decision. It's my understanding that that's the reserved matters which satisfies condition 1 of the outline permission. Is that right?
Yes, that's correct.
And are there any other planning permissions I need to be aware of on this site?
Well, there are the permissions concerning 22D and C.
Yes, but no, aside from
It's on the
those,
site.
those have been referred to by the appellant. Yes, no,
Yeah.
concerning this particular house, and is that right? And just to confirm development plan policies, the enforcement notice and the appeal decision both refer to policies Growth 2 and HOU 5 of the East Cambridgeshire Local Plan 2015. The council's statement of the case is also referred to the Soham and Barway Neighbourhood Plan. Are there any other development plan policies which would be described as the most important for my decisions?
Growth 1, which is levels of housing, employment and retail growth.
Have I been provided with a copy of this policy?
I don't think you will have been.
But what's its relevance to these appeals?
It identifies the level of growth required within the district over the local plan period, so it sort of directly leads into and underpins Growth 2.
Okay. Are there any other policies you're about to read off then?
EMV2, which is called design, but relates to the case in respect of residential amenity. EMV9, which is pollution, so considering noise, lighting, that type of thing, and COM7, which is transport impact, so highway safety.
But do any of these, does the development conflict with any of those policies?
Not with EMV2, EMV9 or COM7, they're not contentious.
Sorry, could you say the ones which it's not
Sorry,
contentious?
EMV2, EMV9, COM7.
Yeah.
But growth one it is.
Growth 1 underpins growth 2, so yes, I would say that's most important.
Okay, so does the appellant have any comments on growth 1 and its relevance to this?
Yes,
appeal?
sir. Several comments on growth 1 and growth 2.
Oh, we'll come. I've got growth 2 and I've got
Right.
comments, and we can discuss those later. But
Right.
growth 1's coming as a surprise to me. If you have any comments on.
Well, as
on
far as
that.
growth 1's concerned, that's just that just deals with the level of housing, and I can't see how that can be a material consideration in this particular.
So
appeal.
is it agreed that it merely underpins growth 2,
Yes.
as the council said?
Yes.
For the council, so everybody agrees on that.
Yes, it's just amends the housing figures that were in the 2015 local plan.
Great. Okay. Thank you. I don't think I need to hear any more on that then. Thank you.
So if I could just make one point on that, it's our position that the most important policy for determining this appeal is in fact HOU 5, and you'll see that in the statement of common ground, that single policy was agreed by the council.
Yes. No. And I've got that. Thank you. Okay. So moving on to the main issues. Please, could the appellant clarify whether any sort of livery business is currently run at the site? No. And does anybody have any other comments on that? And when did the livery business cease at the site?
We think it's 2022.
Well, it is December 2022.
December 2022. Is there anything anyone else would like to say on that?
I'm so sorry. It's not intentional. It might be helpful to hear from Miss Webster either now or I don't know if.
Well, I've got a lot in writing already. There are a few very simple points. If Miss Webster's happy to speak, if you want to turn your microphone on, maybe I could just direct these questions to you, and then if there's anything else you want to add at the end. Thank you. So it ceased in December 2022. What is the site currently used for?
It's not used for anything really, just storage for various different things, but that's about it. The site is dilapidated.
And could a livery business be viable at the site? I don't need full detail. I've got that in written submissions, but I suppose in summary, because I'm going to go around the room and ask people's views on this, how would you like to summarise whether a livery business could be viable at the site?
That's the point that we're really itching to talk about, sir, because it's the key point in the context of this appeal. The point that the council pick up, which is a fair one, and the point that we have to deal with today is a livery business operated at this site for some time with some degree of success in the past. Why can't a livery business return there? And to understand the answer to that question, you really have to understand why Miss Webster moved away from the site in the first instance. And you can hear that from me, or you can hear it from Miss Webster. It might be helpful to hear it from Miss Webster, and then I'll try and chip in, because we've spent some time putting together the timeline, and we'd like you to hear it.
Yes, and then as I said, I've got the written submission, so I don't need all of that detail.
No.
Please summarise, and I'll hear people's views. I've got, like I say,
Are you happy for me to chip in? Because
yes, as and when,
it's
please.
easier for you to have it in structured form, so you can take a good note. But I'll hand over to Miss Webster. I'll try not to be too boring and interfere too much. So
So you just want an outline of why I moved, or?
Well, yes, I mean, what I wanted, I've got written submissions, I can see that there's differences of opinion, but could a livery business be viable at the site?
Sadly not, no. If it could, I would have still been there now.
And yes, I've got written submissions with the appendices referring to why there was insufficient grazing land, why you couldn't rent it. Is there anything else you want to add to that as to why anybody else couldn't?
Only that it's just unviable. It's completely unviable to run a livery or riding business there any longer. The land, there's not sufficient land, unfortunately. And although I was there for an awfully long time, with the yard, all of the stabling has got to a point where it all needs rebuilding and replacing. Absolutely everything.
well, it's perhaps helpful for the inspector to explain, when you were operating a livery yard from the site, you were using more land than is currently available at the site.
Yes, that's correct.
So how was that land made available?
It was made available by the neighbouring farmer.
Okay,
And I was fortunate enough to have that land from him for a long time, which was great. But
and what were the conditions on which that land was let to you?
I was only able to have it on an annual basis, so there was no long-term contract available to give me the assurance that it was justifiable to put a lot of money into the existing yard to redevelop it.
Well, I think that's the key point, isn't it? So it seems that there was a period at which investment became essential.
That's right.
When was that?
Pardon? Oh yeah, and because I have to have a license to run the establishment, and I was getting to the point with East Cambs Council where they would not be willing to reissue my license because of the state of the stabling, and also the lack of land there too.
And you've mentioned to the inspector that the land was only going to be let to you on a yearly basis. Were there any other factors that made the availability of that land insecure or questioned in your mind?
In what sense? I'm not sure.
Well, was there any, who was the relationship with in terms of this lease agreement?
Okay, so yeah, I had previously had a few issues in the past whereby I potentially was going to lose the land. And so I didn't feel confident that it would be there for an awfully long time, and I wasn't able to tie anything up to give me that reassurance.
Well, I know you're trying to be nice about this. When you say potentially you were going to lose the land,
I could have.
Whose fault would it have been, and why were you going to lose it?
The farmer, yeah.
And what did he say? Why did he say it? I mean, I know you're trying to be nice, but there's a relationship that, for whatever reason, led to you being let the land that you needed on an incredibly insecure basis.
That's
so you
right.
need to explain it to the inspector.
Yeah, I didn't feel confident that I would have the land ongoing. I wasn't at all confident that that would stay like that.
It was only offered on short term.
Yeah, and annually, I had to give a year's notice to return the land, or likewise the other way around.
Yes.
And were there any other features that?
Yeah, so I had previously, back in 2016, was putting in an application beside the farmer's farm. And he very clearly warned me that if I continued with the application, he would take the land from me. Subsequently, that didn't end up happening, which I'm very pleased about, but that was very clearly the case on that occasion.
Right, no, I understand, thank you.
That's the critical background. We've got this yearly tenancy, effectively, or tenancy that can be severed, or lease rather, that can be severed at a year's notice. And then we've got this additional conduct, threats of the land being taken away with perhaps no notice whatsoever. And then what Ms Webster says is that we have this key pivot moment where there is the need for significant investment for her licence to persist. And we're talking investment to the tune of several £100,000. So she needs that for her licence to persist, to update the premises. That's when it seems to me that she considered whether it was ever going to be appropriate for her to invest that amount of money when she didn't have the security of a longer term agreement. And you'll see those letters that I handed up this morning are evidence that Miss Webster at that time approached other local landowners and said, well, can I have a parcel of your land? And they said no for various reasons. Mr. Smith, who's the farmer, was not prepared to let her any land on more than a yearly basis. And it's for that reason that she chose to move away. And the position, sorry.
So I don't want to cut you off. It's just because I've got a lot written down already.
Yes.
And I think you're going over a lot of what I've got written down. Those letters, which I haven't read yet.
Okay.
Where are those parcels of land? Because I think in your submissions you say that there's a busy road. You can't be crossing the road all
It's
the
a very
time.
busy
So
road.
where are those other parcels of land where you approached landowners to see if you could rent them?
Behind me.
So not on the other side
No,
of the
not
road.
crossing the road, no.
Yes, no, I understand. Is there anything else you'd like to add before I go to the council to ask them whether a viable livery business could be?
Merely the key point is that any person looking to take up the site as a livery yard is in materially the same, if not worse, position as Miss Webster was in at the time she decided to move away. And as you've heard from Miss Webster, she didn't want to move away. She wanted to remain at the site. It obviously costs her a lot of money to move away. She now rents this new property. It's undesirable in a number of ways, and she wouldn't have done it had it not been necessary. So the prospect of another livery business taking up at the site, given there's insufficient land as it's currently constituted to operate, given that further land will not be made available other than on a yearly basis, and given that it needs several £100,000 worth of work to renovate, the idea that any livery business would put its hand up to operate from the site, I mean, it's simply not going to happen. That's our case.
Yes, no, I understand. And the council, you've heard why the appellant said that a livery business couldn't be viable there. Do you have any alternative view?
So we've accepted that additional turnout land would be required in order to operate a commercial livery. Excuse me, but it has been operated for decades in that fashion. So additional land rented from neighbouring owners, and it's our understanding that that has been the case from the beginning. We've had no information as part of the planning application as to where that rented land was situated, why that agreement had ended. The neighbouring landowner attended our planning committee and stated that firstly, the land was potentially available to a future operator on the site, so they would potentially rent it out to someone else. And they also expressed an interest in purchasing the site themselves and operating it as a livery. And we think that the lack of marketing exercise, without that marketing exercise, it's not been definitively demonstrated that it is an unviable site.
And what would you expect to see if someone was to definitively demonstrate, as you put it, that it's not viable?
So an unsuccessful marketing exercise, essentially, which is 12 months in our policy.
And that would be 12 months marketing for the whole of this site, the house and the stables together, or just the house, just the stables?
So it'd be the house and the stables and associated land.
Yes, and does anybody else have any comments on whether a livery business could be viable at this site? Mr. Young?
I just clarify a contradiction in the statements that were made there. The appellant had stated quite clearly that they would still be on the site if it wasn't for the land becoming dilapidated, but she also pointed out that a conflict rose when she submitted a planning application for 18 houses on the land.
But yes, and would anybody else like to make any comments as to whether a livery business could be viable at this site? Yes. And sorry, your name, was it Mr. Smith?
Yeah, we own the land that Miss Webster gave up, which was her decision to give it up. She had previously, a few years earlier, given up some other land that she rented because she said she had too much land. She'd given another 4 acres up.
Sorry,
probably
could
10
you go back to the beginning now? I think I missed the start of what you were
Sorry.
saying.
Miss Webster gave the land up. There was never any pressure for her to do so. That was her decision. I believe she wanted to move, and that's why she gave the rented land up. She'd had it for quite a number of years. She'd actually had more land than she had at the time, but she said that probably might be 10 years ago now that she had too much land, and 4 acres she gave up, which was adjacent to her. So there was never any problem with her renting the land for the foreseeable future at all. That was her decision to terminate the agreement.
Thank you. And yes, any other comments on whether a livery business could be viably run from the site before I give the appellant the opportunity to final comments on this point?
So I suppose I better come back on those points in turn. The council started by referring to this.
Could I just say that the land is still there for anybody who wanted to run a livery business. The land is still grassland, and that is still available for anybody who needed to run a business from there. So I would have thought that was perfectly viable for somebody else to do the same thing.
Thank you.
So yes, the first point is it's been operated for decades in the past point. I've already addressed you on that. I don't propose to repeat my answers. You have our case on that. Council said that insufficient information had been submitted as part of the application. Hopefully I've addressed you on that part already as well. We've clarified what our case is. You've heard from Ms. Webster on those points. You've heard from Mr. Smith, there's landowner or the adjacent landowner land is available. You've heard from Ms. Webster as to the conditions on which that land was made available to her. In my respectful submission, that's likely to be the condition on which they're available to any future landowner as well.
And yes, the council mentioned that it would have expected a 12-month marketing campaign for the whole of the site. So to show that it's not viable. And yes, I've got some written submissions. Is there anything you'd like to add on that in response to the council's?
We know that's the requirement. It's always been known that's a requirement. You will have seen in the application why, and you've heard today, why it would have been fruitless for us to engage in that marketing exercise. The result would have been that this property would have been empty for a year, and we'd be in the same position that we're in now, a year down the line. I'll pause there. I've got one more point that I would like to address you on, but I'll pause there to see if Ms. Webster wants to say anything about that marketing point. Giving up
with reference to the fact that I did give some land up that belonged to Mr. Smith, that is correct, but I have very good reasons behind why I did that. One is that the land was a bit further away than the stable yard, so it was more difficult to get to. But secondly, and more importantly, the cost, what I was charged for the land, was way over the market value. Market value, as I believe, is £150 approximately to 180 per acre. I was paying 400 per acre. I couldn't justify the cost that I was having to make for the extra piece of land, hence why I gave that part up.
Okay, so if I understand, Mr. Smith, you rented land from him?
Yeah.
And then you rented land from somebody else as well, is that right?
No, just Mr. Smith.
Right, okay, I understand.
And
So
I-
when you were saying there was a disagreement over a planning application, that disagreement was with Mr. Smith, is that right?
Yeah, that's
Okay, I
right,
understand.
yeah. And that's the only reason that I gave up that small portion of land, is it wasn't justifiable, the cost that I was being charged for it. I did give the land back myself, but that was obviously once I then realised that I couldn't really justify staying there.
Yes, no, I understand.
And there was finally an allegation of inconsistency between Miss Webster's submission about the dilapidation of the site and inherently the amount of money it would cost to bring it up to scratch to operate as a livery yard. It was alleged that was inconsistent with the fact that an application for planning permission had been made there. That's what Mr. Young says. We say there's no such inconsistency. You will see the condition of the site when
I think Mr. Young's point was that the disagreement regarding a planning application was Miss Webster's application for 18 houses. It didn't refer to the condition of the buildings. I think, was that the point you were making, Mr. Young?
Yeah, the point is simply the 18 houses that were planned would have taken up the whole stables,
And
therefore showing no
my
regard
understanding
for.
was you were saying that that was what led to disagreement with, as I now know, Mr. Smith. Is that right?
My understanding, but my point was that if you put 18 houses on a stable yard, there is no stable any longer. So the intention was clear to use the whole stable land for 18 houses.
Well, it just goes to the point the stables aren't in adequate position to be used as stables, doesn't it? That's what we say. They're so dilapidated, they should be pulled down. That isn't the application that's made.
No, I understand.
I don't need to address you any further on that, sir. So are there any responses that require further clarification? Would it help?
No, I don't think so, no.
I'm grateful.
May I just come back for the council, sir? Just on the issue of marketing, I mean, I think that the position as we find ourselves in now is that when the application was made, I think it's fair to say that a lot of the information that's been produced today, or a lot of the narrative that's been produced, was not available to us at the time. There is still obviously uncertainty. I mean, you'll see when you read the letters that have been submitted today, there's obviously uncertainty about exactly what land has been sought, exactly, the values of the land that would be charged by landowners if it were to be rented, the potential for short or long-term leases. None of that has been provided formally in evidence, and we haven't had the chance to assess that yet. And I think our point is that that is exactly what a marketing campaign or marketing exercise would demonstrate. The site would be marketed. Anyone who was interested in buying it could look into those agreements, the availability of land, the level of investment that's required in the site in order to bring it up to an acceptable standard. Again, there's no information been provided about what that level of investment would be. And in our view, that is what a marketing exercise is partly designed to achieve, is that anyone who is interested in taking on the site and securing right to any other land in order to make the proposal viable, that would all happen as part of a marketing exercise. And if at the end of that there's no interest, then we would say that's been demonstrated. So that's the council's position on that.
I fully hear the force of that, and I think it's entirely fair to say that there are further details that have emerged that probably aren't in the written case. The observation that I would make is that the nature of the marketing exercise will not be to package the site up with adjacent land that may or may not be available. That's not part of the thing that will be marketed. The thing that will be marketed is the dwelling and the land that is available to Miss Webster. And what you've heard, which I don't think is challenged, is supported by the vet letter, if I can call it that, and the riding school letter, is that the land as it is cannot operate as a livery yard. So any would-be purchaser of the site, and that's the thing that would be marketed. So any would-be purchaser would be looking at not only purchasing land that couldn't function as a livery yard, but they would also have the additional task of themselves trying to find adjacent land that may or may not be available to bring it forward. That's the thing that would be marketed.
Yes, and I understand that council doesn't dispute this, that to run a viable livery yard there, someone's going to need to rent or acquire land elsewhere. Is that right? That the council doesn't dispute that?
We don't dispute that more land is required
Yeah, and
what we dispute is that it wouldn't be possible as part of a marketing campaign. If that's the appellant's argument, that you would package up the land and that in marketing that no prospective purchaser would have the inclination to seek out neighbouring landowners as to whether more land was available. I mean, I think that's, from our position, perfectly possible, and a necessary and kind of rudimentary part of anyone interested in taking on the site. Not that it would be, obviously wouldn't be, you know, that neighbouring land wouldn't necessarily be available for sale, but those anyone interested in taking it on could make those inquiries themselves and enter into whatever agreements they felt necessary.
Yeah, I don't disagree with that. I think it would be up to any would-be purchaser to first of all realise the thing that was being advertised was incapable of operating as a livery yard, and then to engage in the secondary research of, is there any land available that can make this enterprise operable as a livery yard? And you have our case there as to whether they would find that. As to whether in a year's time anyone would conduct that exercise, I think it's extremely unlikely. It would require someone to look at the thing that was being advertised, realise that it couldn't possibly operate commercially, and then to engage in some sort of search for land around this site.
Yes, I've got your submissions on that.
Yeah, well, I don't need to say any more, so that's our case. Please.
And I've been referred to two other houses. I understand that's 22C and 22D Northfield Road, which were permitted next to the house, which is the subject of this appeal. Was that land formerly grazing land associated with the stables? And so how has the development of those houses affected the viability of an equestrian business at the site, or a livery business at the site?
That was literally one paddock, so it didn't really make an awful lot of difference at all. It's important to say how very difficult it is to make ends meet sometimes when you've got horses and staff and everything else. So it's not an easy business to run by any means.
So that one paddock, how many horses? How has the loss of that one paddock affected any viability there?
It didn't affect it.
So would the business still be unviable if those houses, if that land was still grazing?
Absolutely. Yeah.
And does the council disagree on that?
I think obviously the additional land that was sold off now means that's not available, but I think it's accepted that at the time it was sold off, and in any event, were the livery used to continue on that site, more land was required and would be required in the future beyond that paddock. So I don't think we. Yeah, I don't. It obviously affects viability potentially at the top end of what somebody could do across a wider site, because it's less land, but it's not something I think that's key to the viability of the site, because because the additional land would have been required in any event outside of the site.
Yes, thank you. And does anybody else have any comments on that?
I think it might be. I'm so sorry, so Miss Webster just I think wants to tell you what the size of that.
Yes, you said it was one paddock. So
yes.
do you know the size?
Yes, the size exactly I'm not certain of, but it would be literally one horse that would be in that area.
Do you know the area, the size?
Not off the top of my head. No more than half an acre.
And does anybody have anything they'd like to say on that? Yes, Mr. Young.
I mean, if you look at the aerial view of the site, the two houses takes up a quarter of the site. In addition to that, the property that Miss Webster built in 1991, which was subject to the planning condition, takes up another quarter of the site. And I think we're getting slightly distracted from the fact that that was the entirety of the site that was giving the planning condition in 1991. The planning condition in 1991 was not given subject to renting additional land. So the only material change that has taken place subject to that planning condition has been the removal of the land of the two houses.
Do you, and sorry, are you saying that the business may have been viable if these houses weren't built on that land?
What I'm saying is that the planning obligation, that's the only change that's taken place since the obligation was put in place. I'm not here to comment on how much grass a horse needs. I'm just saying that if you've got credibility in determining you don't have enough land to run a business, you shouldn't be selling two houses on it.
Yes, no, I understand. And is there anything the appellant would like to come back on?
Well, I say yes, Mr. Young's quite right. He doesn't have any experience as to how much space is necessary to run a livery yard. I think that's the key point. And of course, when the enterprise began in the first instance, some 35 years ago, it began at a significantly smaller scale. As the council agree, selling off of those parcels of land, which have now include dwellings, makes no difference effectively to the overall capacity of the livery yard, because additional land was being rented once the enterprise reached a certain size.
And is there any need for the condition as it currently stands in its current form? The council, please.
We think the condition needs to remain until it's been demonstrated that HAL 5 has been fully complied with.
And if this condition is very specific to the site, is this the same condition the council would use if it was granting planning permission for a house there relating to the site today, if the house wasn't there?
So if we were granting a rural workers dwelling now, would we use the same condition?
Yes, I've seen, because HOU 5 refers very specifically to various people employed in rural activities. Is it normal now for the council to use a general condition, or to tie occupancy to a particular site at the moment?
Yeah. So it will depend on the case, basically. In some cases, it might be that we would tie it more specifically to the site. So, for example, name the farm or holding, but in other cases, to have a wider condition.
So it's still normal practice for the council to tie particular dwellings to a particular site, as is the case in this
Yes, yeah.
instance?
Just to follow up on that, sir, if I may, I think it just depends on the specifics of both the siting, the case itself, and also potentially the use. So we both use general agricultural occupancy conditions, where it might be say a rural use that was considered to be a rural use, but a very specific one, or a very specific reason for it being needed on that site. We might use a more bespoke condition, but it's not uncommon for us to use what would be considered to be a model rural workers condition.
So on this site, would you still use the condition which is there today, tying it specifically to the site, or a general condition?
I think if we were looking at a new dwelling now to support a livery use on the site, if the justification for that has been specifically on the need for a manager's dwelling, say, for specific reasons in terms of care of horses or what have you, then we might well use a specific condition. restricting it to that particular use on the basis that that's the authorised land use.
Right, so if I understand what you're saying, there's no reason to not, you would use this same condition today, is that right, on this site?
I think save for, I mean, I think we would probably word it slightly differently, and we might take out specific reference to, you know, a named business out of it, but I think we would look to impose a similar condition, yes.
So what are the factors which would be the difference between a site-specific condition and a general rural workers condition?
I think that on the basis on which it's justified. So the justification that's put forward for that, for the need to have a dwelling on site.
Okay, thank you. So what would you say in response to that?
Two observations, sir. The first is that in answer to the earlier part of your question, the council, it seems to me, don't make a positive case that the site could be used as a livery yard. What they say is that it should have been, well, we need to demonstrate it, and we should have marketed the property for a year to show that it can't be used as a livery yard. But they're not saying it can be. They're just saying that we should have marketed the site entirely in accordance with the local plan. We know that's a requirement of the local plan. So we've hopefully explained to you today why that marketing exercise would have been fruitless. You've heard our case on that point. The second point is that in respect of whether the condition would be the same if it were remade again today, there isn't, as you've already heard, as I think is agreed, there's no livery yard actually at the site that's operative at the moment. There's no Old Tiger Stables business that's operative at the site at the moment. So it can't, we say, be appropriate for the condition to remain as it is. It couldn't be appropriate for it to work in that way. Is there anything else?
Just to come back on that point, so well,
I just one moment. I'll just let the appellant see if they had anything
Thank
else
you,
to
sir.
add on that.
Yes.
Yes, sorry.
yeah, just on the point of, I believed you were asking me a slightly hypothetical question in as much as if we were considering this again today, would we do the same thing?
Yes.
In terms of the nature of the condition, obviously we accept there isn't a business on the site at the moment. That's so just to clarify on that point. And also I think the appellant said that, you know, we're requesting a marketing campaign for a livery use that is not on site. I think again I would just go back to the fact that up until very recently, a viable livery use was operated from the site, and that we're not persuaded that currently without the marketing that one couldn't be, whilst accepting that additional land is required to do that.
So was there anything anybody else wanted to say on this point? And just following on from that, does the council say that the condition as it's currently written, do you say that it meets the tests in the framework, in the National Planning Policy Framework, at paragraph 57, whether it's necessary, relevant to planning and the development, enforceable, precise and reasonable in all other respects?
Yes, we do.
And does the appellant consider that the condition meets all of those tests?
No, so it's obviously unnecessary. There's no livery enterprise at the site. It's not a relevant planning consideration. In fact, it's contrary to good planning, because whilst it's in place, you have a residential resource that can't be used, can't contribute to the supply, because the site can't be residentially occupied because there's no livery use there. So it actively frustrates good planning in the local area, we say.
The livery use is the authorised use of the site, though. We're not disputing that, are we?
I don't have any criticism with regards to the precision of the condition. The criticisms are on the basis it's unnecessary and it's irrelevant.
Yes, and does anybody else have any comments on that?
Sorry, if I may, just a one comment on the good planning as the other side have raised. The point of a local plan is to ensure that we get the right development in the right place. The local plan policy is clear that it seeks to have the appropriate rural restrictions on rural dwellings. The council has an up-to-date housing land supply, and therefore it considers that the condition very much promotes good planning because it is seeking to retain a rural dwelling in a rural location. Thank you.
The 5-year housing land supply provision is a floor, not a ceiling, as you know, sir. The position that we'd be in if we retain this condition is that property that could otherwise be residentially occupied, I say that in the context of there being a housing crisis in this country, would not be able to be residentially occupied. There is a plan-led approach to how this exercise should be performed. It's the application of policy HOU 5. We know that. The key limb of that policy that we haven't complied with, we don't shy away from that, is the marketing exercise. But the local plan otherwise provides very clear circumstances in which a dwelling such as this can be released for market housing. We say that full compliance with policy, i.e. the application of the marketing requirement, would be fruitless because, well, for the reasons that I won't repeat already. So essentially what we're saying, sir, is that the plan-led approach, albeit with the slightly pragmatic approach to the marketing exercise, is that this property should be released for market housing.
Yes.
I accept entirely that it's outside, it's in the open countryside, but it's there now. That's the starting point. We're not applying to build this property in the first instance. We're thinking about what should happen to it now that it does exist. And that is not a rigid application of growth 2. It's a contextual analysis containing growth 2, but applying in a pragmatic sense, in this case, HOU 5.
And just to clarify, you talked about HOU 5. That's the exception.
Yeah, that's the exception.
In growth 2 that you're
yeah,
that's the only one you're referring to.
So yes, and that's how it all fits together. There's a as I say, there's a plan-led approach to this. I accept the local authorities say that we've done it the wrong way because we haven't complied with the marketing element of that policy. But as we say, there are good reasons why we haven't done it. And again, the release of dwellings such as this, which have become effectively useless as encumbered with the current condition, is a circumstance that is provided for by HOU 5. And we say a pragmatic approach to that policy means it should be released. The way it should be released is by the removal of the condition.
Yes, and HOU 5, as I touched on earlier, I've got it written. I'll just read this out to clarify. It says that where a new dwelling is permitted outside the defined development envelope, the occupancy will be restricted by condition to ensure that it's occupied by a person or persons currently or last employed in local agriculture, horticulture, forestry, stud and other rural activities, or their surviving partner or dependents. Now, the council said sometimes you'll also apply a site-specific one, and in this case, it would depend on the justification. What I'm struggling to understand here in respect to the Section 73 application, because I'm considering a separate application here for the house, whether you would put one of those generic conditions on, or whether you would put the site-specific condition on that you as it is in this case. You've said it depends on the justification. The appellant has said why they think that there's no need for any condition. What would you do in those circumstances?
Yes, thank you for that. So, I mean, I think we were about to come back and just check whether or not we were going to ventilate the idea of a varied condition, which was not my understanding of the question that you'd previously asked me. But if that's the case, then I mean, I think we certainly disagree with the appellant that in the event that you find that the specific condition is no longer required, that the de facto situation is that no condition should be applied. to the Section 73 permission. Our view is that if we were in a position where the restriction for a livery was too specific, that we ought as a first position to consider a wider agricultural occupancy condition. And I think in your pre-hearing note, you proposed such a condition, and
I didn't, just to be clear, I didn't propose it. I put it forward as a model condition so that everybody could consider that and be aware of it.
Understood, yeah. And I think in that situation, our view is that condition would be, or a variation of would be appropriate, and we can talk about the specific wording of that if that's necessary. I just wanted to clarify that our position is not that it's, that it's the specific condition that we've already got or nothing. We think that the policy itself would lead to the application of a less restrictive but still agricultural occupancy.
Yes, I'm mindful of the time and we haven't had a break yet. I'll just offer you an opportunity to come back on anything the council has said then, and then we'll have an adjournment before we discuss the model condition there and anything else surrounding that.
Yes, I think there is a danger of restriction for restriction's sake in this case. You have, of course, the adjacent residential properties which aren't encumbered by any sort of occupancy condition. And that, of course, is important context for considering whether there should be one in this case. As I've already set out, sir, the correct approach is a plan-led approach, albeit with the caveats that I've already explained in respect to the marketing exercise within HOU5. HOU5 is a guide to whether the relevant occupancy condition is removed entirely, not whether it be considered to be varied. So what the local plan says is that if you satisfy these requirements, the plan-led approach is that the relevant occupancy condition will be removed entirely. I accept wholly that you have the power to substitute vary a condition if you think that's appropriate. Obviously, the local plan doesn't cut across that power, which you have. But the position is that the plan-led approach is that if you're with us on our argument on HOU5 as amended, then the condition should be discharged entirely. That's what we say about it, sir. There is, of course, the additional point that there are there's no permission for the remainder of the site for horticultural, forestry use, etc. So you could be in a slightly difficult position, I think, in respect of the occupancy condition were it to be varied.
Sorry, because there's no horticultural or agricultural use at the site.
Yeah, I think that's right.
I think we'll return to a discussion
yes.
about the model condition later on anyway. That's something to talk to think about. Okay, well, the time's 11:40. I think it's a good time to have a brief break. We'll have a 15-minute break until 5 to 12. Mr. Young, that late evidence, the council took copies. Yes, if you could give me a copy, please, and a copy to the appellant. Thank you. I'll have a look at this in the adjournment. Well, in fact, it's 20 to 12, so we'll adjourn until 12 o'clock. And I'll have a read of that in the break. And if both of the parties could check that this is what they previously read before today,
it is
as well, so that we're all on the same sheet there. Okay, thank you. It's 11:40. The hearing is adjourned until 12 o'clock. Thank you.
What should we go to our little room?
which was set out in my pre-hearing note. And as I said, it wasn't a condition that I've proposed. I've simply put it there so that everybody has a copy of it and for discussion purposes, so we can discuss that. And policy HOU 5 refers to where a new dwelling is permitted. I read that out, the purposes of an occupancy condition, that it would be in effect there. Is there any dispute that a livery business would be rural activity in the context of policy HOU 5?
Probably a matter of planning judgment. Be a matter for the local authority to consider the circumstances whether the condition was to be breached. It would be for them to enforce the condition. And be up to them to think or to consider whether delivery business was a rural use or not. I would have thought it would be.
And would the council consider a livery business a rural activity in the context of policy HOU 5?
Yes, we would.
And would the appellant dispute that?
Dispute was
That a livery business would be a rural activity? No. And policy HOU 5 outlines the circumstances where, as an exception to policy growth 2, new houses will be permitted in the countryside. In particular, is it claimed that any of these exceptions would apply in the appellant's case?
the exceptions that are, well, what are the exceptions to growth 2?
No, to HOU 5.
Sorry, I'm just turning up, so I haven't advanced it. Oh, sorry.
In particular, I'm looking at on policy HOU 5. It has the exceptions where new houses would be allowed, and in particular, I'm looking at 1, 2, and 4.
So the first of the bullets.
Yes.
2, and then 1, 4. Yes, it's a slightly artificial exercise because this is the no doubt the test that was applied when, or a similar test would have been applied when considering whether to grant permission for it in the first instance. But it seems to me that it's policy, it's or sub on bullet points 1, 2, 4, 5, and then 7, probably 8, although I accept we don't have any landscape evidence. And then probably at the time, the final bullet point as well.
Would have all been satisfied.
Would probably all have been satisfied, but it's difficult because a different local plan would have been in place at the time, and we haven't got the considerations that led to the dwelling being granted as an exception in the first instance. We don't have that reasoning. I haven't seen it. But it would appear that those elements of the test would apply were such an application to be made now, assuming that we were in the position we were in 1992, effectively.
Yes, and is that right? Does the council agree with that?
With what
That
specifically?
these exceptions in HOU 5 would have been met for the house?
At the time of originally granting the permission?
Yes, and it's the same situation now, isn't it? Except for the delivery business has ceased.
Yes, I think it would have been similar, certainly similar considerations. I think there was an old, it might have been an annex to an old PPG that was probably in play at the time, around financial viability, functional need, for a manager's dwelling on the site. Yes, but it would have been those same sorts of considerations.
So before allowing a house in the countryside, you would expect to see viability information, would you, for a rural activity like this?
Yes, I think that was part of one of the tests at the time, and obviously as part of the policy that where that can't be demonstrated, a mobile or temporary home is normally suggested as an alternative to a permanent one until such a point that viability can be demonstrated.
Okay, so with this in mind and policy HOU5, is there any need for an occupancy condition at all in its current form, or in a different form which refers to in the model condition referring to a generic rural worker? Is there any need for that condition?
Yes, there is. Yeah.
And what is that need?
Why is an agricultural restriction required? I would say in terms of growth 2, which seeks to restrict market housing in the countryside, except for certain exceptions, one of which is for rural workers. And obviously policy HOU5 also has a section which deals with the removal of an agricultural occupancy condition. But yes, in our view, in order to uphold a plan-led approach to the location of development, that condition would a condition would still be required.
Right, and I know we're covering points that have already been touched upon before, but this is just for completeness. Why do you not agree with that? Well,
So yes, I'm sure made this point a number of times, but our view, there's no occupancy condition of any kind required, because firstly, we satisfy the requirement for the removal of such a condition under HOU5. That's the first reason. The second reason is that there are 2 properties next door that don't have agricultural occupancy conditions of any kind. So we say plan-led approach, applying the provisions of the local plan. HOU5 says you don't need to have this occupancy condition anymore because we meet the criteria, or the criteria needn't apply. That's the first point on plan-led. Second point on plan-led is that you'd be in an area where your neighbours didn't have an occupancy condition of any kind, and the council would be suggesting that you needed one, or one needed one at your property for almost no reason. So what we'd say is that you'd be in a position there where that's an occupancy condition for an occupancy condition's sake.
would the appellant be left in a worse position than before the appeal was made if condition were discharged and an alternative condition substituted in its place following the model condition?
Would depend. Oh, if it followed the model condition?
Yes.
No, it'd be in a better position, sir, definitely. But that's no prejudice to our argument that it should be removed entirely. But it's obviously the case that Miss Webster would have more freedom as to how the property was operated, how it might be usefully marketed in future with a new condition. But as I say, that would again would result in a slightly odd position locally, where you'd have 22C and D being residential premises that don't have any condition whatsoever, and then you'd have the property effectively next door to it having a broadly worded occupancy condition, perhaps on the simple basis that that would represent a compromise between removal and retention of the previous condition, and all of that would be in a context in which the local plan tells you that the condition should be removed, which is what we say. Yeah.
Was there anything you wanted to add to that? And the model, the wording of the model condition, does that meet the test set out at paragraph 57 of the framework?
So yes, it would. As I say, sir, Ms Webster would be in a better position than she is now with that condition. But I think the most compelling argument as to why such a condition shouldn't be applied is that it would not represent joined up planning in the local area, because it would be inconsistent with the permissions granted at 22C and 22D, and there is no good reason why this property should have that encumbrance when those properties don't. And as I've said, applying the local plan policy HOU 5, that sets out the circumstances in which removal of the condition will be appropriate, rather than substitution for a watered down condition.
May I just come back on?
Thank you. Yes,
a
yes,
couple of
please.
ones? I mean, just in terms of the two dwellings adjacent the site, which have been granted without restriction. I mean, I think it's important to say that they were granted at a time when the council was not able to demonstrate a 5-year supply. So we would say that the considerations are materially different in terms of the weight to be given to local plan policy. And we can rehearse those arguments more if you like.
Just to be clear, I've got those arguments, I think,
Fine.
in their entirety set out in writing.
There is perhaps one thing.
I'll let
I'm
the
not
council
gonna
and I'll go
cross-
around
of
and then
course.
come back. But I don't need to go into detail as to what circumstances led to that. And I've got the discussions about whether it's a sustainable location or not. If anyone wants to add to that, they can. I think I've got everything I need in writing. But yes,
Understood.
please go on.
Yeah, and on the issue of the application of policy HOW 5 in respect of removing, rather as the other side has suggested, that policy leaves no room for variation and just addresses removal. That is framed in the context that a wider agricultural occupancy condition has been applied. So the element of the policy which refers to what needs to be done in order to remove that refers to a condition which is of the nature that you have provided in your pre-hearing note, a wider agricultural occupancy condition, not a specific one. And so when they say that the remainder of that policy allows no provision for it to be varied, we would just point out that that's because the starting point for that is that a wider agricultural occupancy condition has been applied, as opposed to a situation where I think our view is, in terms of what that policy drives at, is that it is absolutely legitimate to look at a wider condition in this context before moving to the point of saying it should be removed in its entirety. That is a perfectly reasonable and logical next step if your view, sir, is that the existing condition shouldn't remain.
But the policy doesn't make any differentiation between conditions which are specific to the site or general. It says applications for the removal of an occupancy condition related to rural workers will only be permitted where these 3 bullet points can be demonstrated. Is that not applicable to a site-specific condition such as this? Is that what you're saying?
I would say it is applicable, but it flows from a situation where a wider. I'm not saying that this policy doesn't apply to that more specific type of condition. My point is that it flows from a situation where you are considering that wider agricultural occupancy condition. And so that's why it talks about removal only as opposed to variation.
Okay, and so you're saying it flows from that because of the preceding text there underneath the bullet points, is that right? Even though the final line refers to just a rural worker, is that what you're saying?
I'm saying, yes, I'm saying it envisages or it is discussing a situation where there is a wider agricultural occupancy condition on a property and therefore is framed in terms of removal. I'm not saying the thrust of the policy can't apply to a narrower condition, but I don't think the way it's framed undermines the council's ability or your ability in this situation to apply a wider agricultural occupancy condition.
But just so I'm clear, nowhere in the local plan does it refer to these two different types of rural workers conditions, a site-specific one and a generic one. And you said that the council uses both types at various times, but I'm not missing something. This is the only policy which refers to these occupancy conditions. Is that
That's
right?
correct, yeah.
And just to come back to the appellant, the council said that the way that policy HOU is framed, it does not undermine an approach where you would replace a site-specific condition for a generic condition. Do you agree with that or not?
So in my respectful submission, that's not the correct interpretation of the policy. The policy is put in general terms. It's the final bit of the policy that straddles pages 49 to 50. Onto page 50, it's very clear the terms are general. The removal of an occupancy condition related to rural workers will only be permitted where it can be demonstrated that. And there follows the criteria which govern when occupancy conditions generally may be removed. And that's what we say. And so there's just one point I wanted to dig out, a reference for you. I know you've read this, you've read our competing cases on the sustainability point. The point being that the dwellings at 22C and D don't have any occupancy condition, and how that would tally with any removal or amendment to the condition. We say obviously it should be removed because that put all the local dwellings on parity in terms of how they were conditioned or not. It's worth going to the officer reports for the dwellings under reference 170291/FUL.
Sorry, could you say so?
It's 17000291/FUL.
So this is the planning permission for the two neighbouring.
The adjacent dwellings, so yes.
And the officer report.
The officer's report.
And this has already been provided to me in the appeal submissions.
You have those, I think so, yes. But I just
bear with me one moment. Are you going to refer to a specific paragraph?
I'm going to refer to only, well, one paragraph really.
Okay, if you could bear with me one moment while I try to get a copy of that document up. If you happen to know where it was provided to me, that officer report as well, if it's one of the appendices.
I suspect, and there's a document that, is it there? I don't think it's been provided to you, sir. But it's part of the planning history. It's quite helpful.
But if you could, are the paragraphs numbered?
They are, so yes.
If you could just provide me with the paragraph number, if I've been provided with it, I can refer to it later and then make the point that you'd like to make.
I'm
please.
grateful. Do you think you could send it to?
Are we introducing new evidence?
Well,
I want to be
I think
clear about what's happening.
No, I think he's right in saying that it is part of the planning history, but yes, I don't want to be provided a copy of the officer report if I haven't already, but I think it's only fair that he can read part of a previous officer report out of it's part of the planning history.
So yes, I'm grateful. It goes to.
But I would like to know the paragraph number in case I have already been provided.
I'm going to give it to you, sir. It's paragraph 7.2.4. And what the officer says is that the sustainability of the site has been considered by an earlier committee on the 2nd of November 2016. And he says that members considered on that occasion that this site constituted a sustainable location, and this is the critical bit on which I rely, due to its close enough proximity to the built-up area of Soham. That this site constituted a suitable location due to its close enough proximity to the built-up area of Soham. And that point is effectively repeated at 7.10.3. And then the officer concludes at 7.10.5, and this is the last paragraph I rely on. The application is considered to be broadly in compliance with the relevant local and national policies referred to above. So what I say about that, sir, is that the reason that it was the adjacent dwellings were found to be sustainable was because, well, it was due to their close enough proximity to the built-up area of Soham. That's what the officer says. And then the officer has plainly turned his mind to whether he agrees or not with that consideration, which is a consideration reached by members on a previous occasion, in paragraph 7.10.5, because he finds the application is broadly in compliance with the relevant local and national policies.
Yes.
And so, as far as it goes, just so you have our case, the other side say the conclusion on sustainability is some sort of 5-year housing land supply related exercise. We say it isn't. The planning committee were attracted to the conclusion that the site is sustainable due to its proximity to Soham. That's what they say. And the officer turned his mind to that consideration in the consideration of the 2017 application, and he agreed with them. That's what we say about it.
Yes, and I've got that in writing. Is there anything that the council wants to add to that? Because I did cut you off earlier when you wanted to talk about sustainability. In the context of what the appellant said, is there anything you'd like to add to what's already been written?
No, we would just note that that was done in a different context under the tilted balance, so that that application was considered at a time where full weight could not be placed on growth 2 due to the lack of a 5-year housing land supply, and sites outside of development envelopes were therefore in play. And that is not the case at present. And many appeal decisions that we've had recently have confirmed that the council's got a 5-year housing land supply and should give full weight to its locational policies, primarily growth 2 and the exceptional policies that flow from it. And the only other point I would make is that I think it is evident and will become evident to you, sir, when you visit the site, that it is not a sustainable location. And I don't think, I think committee made a decision in that case, which was based on its understanding of the tilted balance. In my professional opinion, that site is not sustainably located. And I think we would sort of urge you to look at that. And I would also point out that we've had other appeal decisions recently where sites which were previously given permission on Northfield Road for dwelling in the absence of a 5-year supply have since been refused permission on the basis that growth 2 now carries full weight, and that was an appeal against that refusal was dismissed. I can refer you to that decision if you like, sir.
And does anybody else want to make any comments on the sustainability of the location, on the points that have been made here?
Just want to make a very brief point, and happy to be corrected if you feel it is irrelevant, but want to bring to your attention, since there's such reliance on the 2 properties and bringing them into line with those 2 properties, that both those properties are currently unsellable and close to uninhabitable. Happy to be cross-examined on that.
No, I've read the comments that you've made relating to that. And do the council, Mr Young's submissions there, raise any points that you'd like to go back on?
I don't think Mr Young's does. The importance of the sustainability point is merely to compare the residential developments at 22 C and D with the potential unrestricted development.
I understand the
or tiger
point that was
stables.
being made, yes. And
I take it no further than that. It's simply to say there's no condition there. It wasn't considered appropriate to implement a condition there. There's, in the same way, it's not appropriate to introduce a condition at this site.
And to the council, is there any need? Is there any known need, any recognised need for rural worker accommodation generally in the local area?
Difficult one for us to answer, if I'm honest with you. But as far as we are aware, we have a need for all types of.
Sorry, as far as you're aware.
So as far as we are aware, we have a need for all types of housing in the district, be that rural workers, be that market. Thank you.
And does the appellant want to make any comments on that?
We're not aware that there is any need. Miss Webster certainly hasn't been approached by anyone suggesting that they could occupy this dwelling with a view to themselves seeking to alter the planning permission so they could occupy it as a forestry worker or agricultural worker, or anyone associated with any wider agricultural use. That's never been suggested. I don't think has that ever happened during the lifetime? During the currency of her ownership of the property, which I think is some 35 years, she hasn't been approached by anyone. Which may give you some insight into the level of need in it. As the local authorities say, they're doing quite well in terms of their housing land supply, so that may be an answer to your need query.
Is it disputed whether the dwelling has been made available to at least 3 registered social landlords and refused as specified in policy HOU 5?
So before my colleague just comes back on that, if I could just say, I think just finally on that point,
Which point, sorry?
the point you were just discussing as to the known need for any agricultural workers accommodation, that is obviously something that could be would come out, or potentially would come out, of any marketing exercise that was carried out, which obviously hasn't been carried out.
I'm not sure. I think they're quite different things, aren't they? Because one of them is about advertising of this particular property and whether it's attractive, and the other is about generally whether there's a need for properties of this kind were they to be effective. It's a different question.
And yes, sorry.
Because if this property, if we're right and this property can't be used, then for livery purposes or even agricultural purposes of some related kind, if it can't be, then if we market it, it'll show no insight whether there's need for agricultural or livery use, will it?
No, but in the alternative, if it were marketed for a range of prospective uses that could be undertaken without any, some of which could be undertaken without need for planning permission, and it were to generate interest, I think that would show a need. So.
But I think earlier when I asked how the council would expect the land to be marketed, was it correct that you said that you'd expect the whole site to be marketed together, the dwelling and the stables? Is that right?
Well,
we would expect the land to be marketed together, yes, which currently has stables on it.
Yes, yeah. And I think was the point you were making that it depends on what's being marketed there.
Yes.
The house alone or the stables or together.
Yes.
So how would, based on what the council's just said, the council said a marketing campaign would test whether there's any need for a rural worker to live in that house. Are you saying that wouldn't be the case if it was all marketed together?
Well, so yes, because if we're right that the enterprise can't commercially function, then no one even if there's dire need locally for livery use or agricultural use generally, no one is going to make an offer for the property because it can't operate successfully commercially. So what would happen if you marketed the property is you would get no responses, and that might give you it would give you no insight whatsoever as to what the level of local need would be, because the thing that you're marketing is inherently incapable of a viable commercial use. It's not the same as saying, okay, you can have a general livery use at the site, or assuming this property is commercially viable, would you like to live here? That would give you an insight, because people may or may not respond. But no one in their right mind is going to positively respond to this property if it's advertised. So marketing would give you no insight as to whether there is any local need or not.
Yeah, sounds like, yes, please do. I think, sorry, just one moment. Sorry, just one moment. You had finished on that point.
Raymond Smith, I've got,
I'll
No, it's fine, sir. It's fine, sir.
I've got a letter that I'm going to read from my son. I was actually told that I couldn't submit it to you because it was too late, but I've got some copies.
Well, before you go on, what is this?
Well, this is in
to what we're discussing at the moment.
Yeah, because my son is prepared to buy the site. He's interested. He sent a letter to the appellant solicitor, so that he is interested. And I was going to read you what he would have said. He can't be here today, unfortunately.
Okay. How long is this letter?
Very short.
Right. It's more than one page. How many pages is it?
No, there's a little bit of a page and a few.
Oh.
And if you'd like
and
a
this
copy.
so this is concerning your son's
Intention, he would, yeah.
to buy the land.
Yeah.
Okay. Well, I'd invite you to make comments on what we've already talked about, to keep it relevant to what the questions that I've been asking, if you wouldn't mind.
Yeah, I think there is a need for agricultural for properties, and I also do believe that as we've got the land that Lorraine had, that is actually possibly a viable proposition to do so, which is what this letter explains. And they actually can I just read one paragraph?
Yeah, no, please do read any parts which are relevant to what we've been talking about.
In paragraph 4.7.3, the council raises the approach of a neighbouring landowner, Simon Smith, as he expressed an interest in running the livery yard. To reiterate, Mr. Smith has no experience in running a livery yard, and despite his turning up at the planning committee, expressed an interest in purchasing the site. He has not come forward with an offer. He is, as has already been stated, he's clearly a spoiling tactic. Council say that there is no evidence to prove Mr. Smith he has a lack of experience, yet Mr. Smith is not currently involved in any equine related businesses, but he has an interest, and it's absolutely honourable, and he stands by that. And we've got other businesses that we've started and have been quite successful. A lorry business, for instance, and there's no reason, as the land is available to anybody else who wants it or ourselves, we believe that is a viable proposition. And the reason he hasn't bought it because it hasn't been put up for sale, and you can't buy anything that is not put up for sale. That hasn't been marketed at all. He's been waiting for that.
So if I understand what you're saying, it is that your son would be prepared to operate a viable livery business at the site because he owns land adjacent to it.
He owns the land. We own the land that was used previously before that was given up.
Okay, is there anything else you'd like to say on that? Because what I'm going to do, because it's the appellant's appeal, I'll give them the opportunity to have the final comments on everything. I don't want this back and forward. So if there's anything else you want to say on this point before I go over to the appellant to let them respond to you.
No, just that we sort of was waiting to purchase it, and I have a copy. I didn't realise that I could put it as evidence, because I was actually sent an email to say that I couldn't. But there's a copy here if you'd like to read it when you've got more time.
Well, no, so it would be late evidence, and as you've heard earlier today, if I'm going to accept any late evidence, I need to give everyone an opportunity to comment on it. The reason
Yeah, so that's here if,
the reason I accepted Mr. Young's earlier was because it potentially dealt with a complex matter, which I couldn't understand from what everybody was saying. I think what you've said sums up the point that you're making. I don't think I need any further late submissions on that.
Right.
And if there's nothing else you'd like to say on that, I'll hand over to the appellant.
yeah, fine.
Okay, thank you. Yes. Is
So
there
yes, I'm
anything?
grateful. Just dealing with the final point, Mr. Smith made first, that he couldn't look to make some sort of offer to purchase the site because it hadn't been marketed. So as we know, that's wrong. Could have made an offer to purchase the site at any time. He's never made a serious offer to purchase the site. Reading between the lines, it's relatively obvious what's going on here. We've got a site that will be worth less with an agricultural tie to it. Mr. Smith wants to buy the land. He wants to buy it with an agricultural tie on it. That's obviously what's going on in the background. The essence of our case is that had the dwelling been marketed with a livery business with no tie, there's no serious livery business would dream of operating from the site. Mr. Smith isn't here, doesn't operate a livery business, hasn't provided any evidence that he has the funds, the means, the loan facility, infrastructure, any of the equipment, any of the know-how to make any serious claim that should be taken seriously, that he could operate a livery yard. His evidence is not evidence of anyone with livery experience expressing interest in operating from the site. And you have it to the contrary, Miss Webster, who actually did operate a business from the site, saying that you can't continue to do so in the current climate. You have the riding school agreeing, and you have the veterinary practice agreeing as well, sir. Don't know if there's anything more helpful I can do. Mr. Smith hasn't submitted any evidence as to how his approach would be different, how he could bring this business back to life. Or as I say, that he has the hundreds of thousands of pounds that would be necessary to implement the repairs to the business that would be necessary to even begin to consider applying for a license.
But I think, as Mr. Smith pointed out, he has the land. Does that?
He has the adjacent. He has the
Yes.
adjacent land. Yeah. No. Well, that's a good point, actually, Mr. Hutchinson makes. Who's going to occupy the land, occupy the premises? Not Mr. Smith. So he'd be in a position again in which you've got residential occupations not being released to the market. I think the short point, sir, is it's not a credible offer. It's not informed by any of the relevant market know-how that one would need. And what is said is that this offer it cuts across our mission that if the property was marketed for a year, someone might take it up. And we say, for the reasons that I've just explained, it doesn't.
Yes. And yes, sorry to go back to the council. The third bullet point of policy HOU 5, is it disputed whether the dwelling has been made available to at least 3 registered social landlords and refused?
Oh, sorry. No, it isn't. It was done after the application, but it has been agreed and it's in our statement of common ground.
Thanks. Are there any personal circumstances which may support the development without any conditions controlling its occupation that I need to be aware of?
I think it's relevant, sir, that you're seeing the council have allowed Miss Webster to effectively move her business elsewhere. You'd have seen reference to that in our statement of case. So the vacuum left by that permission it's obviously not up to the council to cancel the previous permission at Old Tiger Stables when Old Tiger Stables moves. But it is to some extent the council's recognition that there were good planning reasons for the development to move in the first instance. Is there anything else that you want to say? But so no, there are no sort of acute personal circumstances that otherwise relate.
And other than what's already been said, are there any other reasons why the site may be inappropriate or in an inappropriate location for the development of new housing without an occupancy condition?
So I think you have our case. I don't want to repeat it any further unless it's helpful to cover any particular matters in greater detail.
And are there any other points that the council would like to make on that? On whether the site is appropriate or an inappropriate location for new development without an occupancy condition?
Not from me, sir. I don't know if my
And would anybody
Sorry,
else?
Darren, I suppose I don't want to take things out of turn. It just occurs to me, of course, that's a slightly artificial question because we're not thinking about new development. It's a
Well, no, we are, but in the context of the
Yes.
house already existing, yes. But that's yes. And does anybody else want to make any points on the location of the development? And with regard to, we have the legal agreement, which reiterates the condition. Why do we have the legal agreement reiterating the condition? Is the condition, I think we went over whether the condition met the tests in the framework. Nobody's told me that this condition isn't enforceable. Why is the legal agreement necessary to make the development acceptable in this case?
Can I just clarify if you mean going forward or as it currently stands?
Well, as it currently stands, yes.
I'm speculating slightly, sir, because I am the original permission was from 1991, and so some of the records that we have on it are slightly sketchy. But I anticipate it maybe because it.
Sorry, if I can make it easier, why is it needed now rather than what were the original purposes for it?
So I think that's linked to what I will say about the history of it. So it may be that I think the case that the red line at the time of the original application was just around the site for the dwelling, and therefore a legal agreement including more land as it does was considered necessary. I don't know if that's the case.
Sorry, I don't think I understand that. The red line may have just been around the dwelling. Is that what you're
Yeah,
saying?
I have to say from our records, it isn't clear because they're black and white records. So we're not clear exactly what the situation is around the original red line for the site.
So if we're not clear on what the legal agreement is requiring, does it fulfill any useful purpose now?
The legal agreement itself is clear. It is clear which land it includes.
Right.
So that may be one reason, but I am speculating. I think it does provide a more robust mechanism to secure that link in the future, also going forward. Yeah, it eliminates the sort of 4 and 10 year rule around breach of that, and as is evident, I think from the recent history, it is it is currently being used or was being used at the time of the enforcement notice in breach of the condition. So it's evident that can occur, and I think in our view the legal agreement provides a greater strength going forward, securing that in perpetuity.
But we've got an enforcement notice has been served. It's not alleged that the notice isn't that the breach hasn't happened. Does the enforcement notice not do away with any need for the legal agreement?
I think I would have to defer to my colleagues on that point, sir.
So perhaps I can make a few remarks and the local authority can of course respond.
If I come back to the council on that
Yeah,
point and let the appellant comment up to now.
I'm not trying to steal a march or anything, but we say it's purely duplicative
in terms of enforcement mechanisms, it's actually a worse way of enforcing planning matters because you enforce Section 106 by injunction, whereas you enforce conditions and a number of other means, PCNs, enforcement notices. Much easier to serve an enforcement notice than to make an application for an injunction. As to the time limit point, there's a 10-year immunity period for everything now, all breaches of planning control, whereas there's a 12-year immunity period for breaches of a specialty, which is deed, Section 106. So it doesn't really provide a significant advantage in terms of enforcement time, really, and it's a much more lengthy, convoluted enforcement procedure. And we say, I hear entirely what council say. It's not clear to me why it was included in the first place at all.
And yes, coming back to the council, I was asking, what is there any need for the legal agreement if we're doing away, if we've got the enforcement notice there? And I think also the point that the appellant made, that there's a 12-year immunity period with the Section 106 for enforcing its requirements. So is there any real benefit in it?
The only benefit I can see at the moment is we also have a clause within the Section 106 which prohibits the severance of a land. I don't think that's on the planning permission.
So which clause? There's a clause which prohibits severance of the land.
Yeah, 2C.
2C, yes. And the two houses which are nearby, those are on that land, is that right? So that's already been breached. Okay, so just to return to my point, is there any need for the legal agreement now?
We think there is, yes, in respect of the severance of the land.
To prevent further severance? Before coming back to the appellant, I can see, Mr. Young, is there something you'd like to say on this?
Yeah, I just think clause 2C of the Section 106 is absolutely essential. If you take a total land mass and you keep halving it until there's nothing left, then you arguably have no land left to run the business. So that's the kind of definitive difference between the 106 and the actual restrictions. And I mean, that's evidenced obviously by the houses being taken up as part of the land and sold independently. And just for a kind of, just the clarity of a point that was made, the housing itself, the two houses that were built, planning permission was only actually obtained for half of the land at which those two houses sit on. There is an entire back garden which planning permission wasn't obtained, and it still sits within the 106 agreement. Part of that's owned by myself, part of that's owned by the appellant.
So sorry, if I just understand this, are you saying that half of the land occupied by these two new dwellings does not have planning permission to be used as part of those dwellings?
That's correct.
Okay, and just so, and is that land owned by you and your neighbour?
So part of that land is owned by myself, part by the neighbour and their property. Part of the land, which is still within our boundary fence, is still owned by the appellant. There are, please interrupt me if you feel I'm deviating. There are very large items of our drainage system which should be within our boundary as per building control, but they are outside of our property boundary and on the subsection of land which the appellant is trying to put the unilateral agreement through. If you want me to draw it on the board, it might be helpful.
No, it's fine. I can understand what you're saying, which is essentially the planning permission has been granted for 2 houses on part of the site, which was subject to the legal agreement. That land has been extended in breach, possibly in breach of planning control. That's outside of this appeal, but a larger portion of that site is being used for residential purposes. Is that what you're saying?
That is correct. So there is a subsection within our boundary fence, and then there is a larger portion, which you'll see in the visit, behind our fence, which contains a pond, which takes my surface water, a pumping station, which takes my sewage, a pumping station, which takes Mr. and Mrs. Slater, and then a large open cesspit full of human waste, which takes, because of the dysfunctional system, just collects human waste and spills into the natural environment. So those are all components of my system on the appellant's land, which is why I feel so strongly that the Section 106 cannot be unilateral when my property is effectively on her property.
I see what you're saying. So is this not a breach of the legal agreement? And if the legal agreement's forming a useful purpose, what is there anything controlling this or stopping this? Does the council have any objection to this happening in the context of the legal agreement?
Council's view is that when we granted the original permissions, we should have secured a deed of variation at that time, obviously securing the removal of that element of it, because obviously we granted planning permission for the houses, therefore that portion of the land and that portion of land only at that time was considered to serve no further purpose. There is an element of land which Mr. Young is talking about, and that's under consideration. The council has offered in respect to the areas which have got planning permission, certainly that we would offer a letter of comfort, or we would enter into it. If a deed of variation came in, we would be amenable to that. There's a lot of other elements ongoing at the moment, which obviously I'm not really able to talk about in this forum.
Okay, what I'm trying to understand is that the council has said that the legal agreement's needed because of the clause which prohibits the severance of the land, but we've just heard that the land has been severed not only by the planning permission, but then further with the gardens being extended. This is doing what the council says the legal agreement is to stop. Why is that a problem for the council? Why do we need the legal agreement if it isn't a problem?
Sorry, the difference in the amount of land between the grant of a planning permission compared to the quantum of the whole site and the, I'll use the expression unauthorised element of it is quite small. So the council doesn't consider that that's material with regards to any sort of viable use on the land. So subject to obviously going through the correct processes, I don't think we would object, bearing in mind that land has been sold to Mr. Young. It's unlikely to be brought back into the livery use, that we would have an objection to that being incorporated, not necessarily within residential curtilage for obvious reasons, because there's legal context around that, but certainly within outside of the Section 106 context, if you understand what I'm trying to say.
I think I understand. So if I understand, you're saying clause 2C is needed to prevent any further severance. What has happened so far, including the extended gardens, is acceptable. Is that right?
Correct. What we're saying is what we wouldn't want is we wouldn't want the house being severed from the stabling and livery land in its entirety, or certainly any more than has happened already.
What I'm concerned about, Mr. Douglas, is that my house is severed from its drainage system. What would happen with the unilateral agreement with all the major components of my drainage system currently sitting on the appellant's land that I have no access to? So by further severings, by obliterating the kind of 2C clause and further severance, I would then have a property with essentially no drainage system. And this is something that the Drainage Board is keen to rectify. And just to answer your point on enforcement action, and again, stop me if I'm going too far, but my understanding of the legislation around the matter is it's very difficult to enforce on a developer after the house has been complete and it then becomes enforceable on the occupant of the property. Obviously, the difference here is that the drainage system, which is completely ineffectual and causes fecal matter to rise up into the kitchen and bathrooms, is a drainage system which is solely within Miss Webster's land. Hence why, if I may correct the appellant's legal team, there was no request for a large amount of land in some sort of kind of bargain deal. I was simply offering the 80 to 100,000 pounds of my own money to correct my own drainage system if the land was transferred me in order to do so, and that land would have then been taken out of the agreement, and I would have signed the agreement allowing Miss Webster to lift her agricultural restrictions, because I would have no requirement for that land. But whilst my property resides on her land, there is absolutely no way that I can accept a unilateral agreement.
Thank you. Yes, we've covered a number of points there. I think to give the appellant the opportunity to come back on all of that, I think that's going to tie up much of the main issues.
Additional points that I need to address you on, but in terms of the breadth of an enforcement, or what can be, who can be served with an enforcement notice, you have section 1722 of the 1990
So
Act.
just to interrupt you, I know where you're going with it. I don't think I need to hear
So
that.
you know any
Yeah.
person interested in the land, fine. Mr. Young mentioned the Drainage Board being interested somehow in this application. You've received or you've seen in terms of this planning application what the Drainage Board had to comment. Had no comment whatsoever. We're of course not considering in the context of this application whether to remove 2C. We're considering whether to remove 2B. I accept Mr. Young has a grievance, legitimate or not. You have my submissions at the outset as to the appropriateness of this forum for ventilating that grievance. But insofar as today is concerned, none of what he says is relevant to the question of whether the occupants of 22A Northfield Road should be required to be in livery use whilst occupying that premises. There are other matters with which Mr. Young is concerned, and I have some sympathy with him to some degree, but they are not matters which concern you today, sir. That's what we said.
Thank you. And,
yeah.
so I can see you thinking. I can also see Mr. Smith has taken some, may want to make a point. Maybe I'll come back to you at the very end, because I'm trying to tie up before lunch. Yeah. So yes, Mr.
The
Smith.
appellant says that the Drainage Board don't have a problem with what's there. They actually do. I sit on the Drainage Board. They have written to Miss Webster just before Christmas and asked her for a revised plan. At the moment, there is no way for any water to leave the site, and basically the sewage and is actually going in my ditch and then going into the watercourse, which is illegal.
And I've seen comments on that, but I think, but the Drainage Board haven't objected to the lifting of the occupancy.
No,
condition.
again, not the occupancy, only for the drainage system
Yes.
that's there.
And sorry, yes, Mr. Young, I don't really want a back and forth, but if it's something just to clarify.
Just a point, I would be absolutely in agreement with the submissions made by the appellant had I not received the deed of variation to exclude the whole 106. Prior to clause 2B being the only thing being discussed at this meeting, there was no purpose for me attending.
And I understand. I think the appellant's made clear that that's not a route that's being pursued at the moment.
Yeah, the other thing is, so far as there would be any need, sorry, I keep doing it, any need for a new section 106 agreement at any stage, you will have, your model condition, if I can call it that, doesn't tie the land to the dwelling, I don't think. So it's difficult to see why there would be any need for that to be secured in the 106. But I think that's as far as it goes. So.
Okay, are there any other points that anybody would like to make on the main issues in this appeal? If not, I think we'll break for lunch, and then when we return, we can move on to item 4 on the agenda, other conditions. But is there anything anybody would like to say before we move on to that after lunch?
Can I just say, just looking from a layman's term, if it was advertised for 12 months, you would then find if anybody else was interested. At the moment, we just don't know because it's not been advertised. Nobody's had the chance to purchase it. And we were under the impression that it had to be advertised. So we're waiting for that to happen. And there might be other people who we could rent the land to who would be interested as well. But at the moment, they're not given the chance to actually do that.
Thank you. And is there anything the appellant would like? I've got your representation, but is there anything specific?
Effectively repeating a point like that, it goes to my point as to why he's here.
Thank you. Right, well.
So before we,
yes,
if I may, just before we break, I just wanted to raise with you the fact that we have, in the event that you felt a wider condition was required, and our view in that case was that that should be secured by a Section 106 agreement, as well as continuing to secure the provision that the site isn't subdivided. We have prepared a new Section 106 agreement in advance of the hearing, which was provided to the appellant for comment, knowing that we would need to kind of at least have some agreement on that going forward if we were to give you the option of granting a new permission under Section 73 subject to a legal agreement. I'm not aware as to whether or not you've seen that. We haven't discussed it yet, so I just wanted to put it on the table now for discussion after lunch.
I haven't seen it, and I'm not going to consider any draft legal agreement. The process is, if a complete and signed legal agreement is received by the planning inspectorate before I issue my decision, then I have to consider it. I'm not going to be considering any draft or incomplete legal agreements.
In which case I would just note that we've provided that to the appellant. We haven't had any response on it to date. And if we could discuss it this afternoon, or if they have any view on it, it would be appreciated if that could.
How would that be relevant for me, for my decision? I understand you may want to discuss that with the appellant, but how is that going to help inform my decision if we don't have a complete signed copy?
I suppose it might go to whether or not there's any prospect of it being entered into, which might then inform your decision.
May I suggest that you speak with the appellant during the lunch break briefly about that? So when we talk about it after lunch, it should be fairly brief.
Very happy to, yeah.
Is that a good idea?
Yeah. So
okay. Right. Well, it's just gone 1 o'clock now. I think we should have no problem in finishing here by 3 o'clock to allow me to get to the site by 3:30. Does anybody think otherwise?
So no.
Great. Okay. Well, after lunch, then we'll talk about that legal agreement that you've drafted. Item 4, other conditions, and then we'll move on to make arrangements for the site visit. So the time is 4 minutes past 1. We'll break until 2 o'clock for lunch. Thank you. The hearing is adjourned.